Hi,
Hey, how are you?
good. How are you?
I'm good. I'm just figuring out all this stuff on the fly.
Oh, yeah, no worries.
This is the story of my life. I'm gonna move to a different room real quick. So,
Yeah,
how's everything going?
good, good. Ryan, he was coming like right from something else, so he probably will be here at like 11:55.
All good. No worries. I don't think this requires too much prep.
No, I feel like after the call on Monday, everyone kind of knew what was going on. And for the slides, like we decided to do the slides so we could offer CLE, but we really don't even have to show them. We just have to submit them. So
Got it.
we may, if it's helpful, we'll like use them. If not, it's not a big deal either.
Okay. What is my camera? Um, how is like I've been trying to figure out a good way to do CLEs. It seems like a pain, right?
Yeah, we're lucky because Wilson Sonsini, they're like an approved provider automatically. So we just submit it through them since we're a subsidiary. So
Wow.
we basically just email someone at Wilson and then they give us the paperwork back. It's pretty easy for us, but I think it's not that easy in general.
I need to do more events with you all then.
No, yeah. I mean, I was thinking that like whenever you want to do something CLE provided, we're happy to help out.
Okay, that's great. I mean, employment law obviously is a massive topic of discussion. I mean, we literally just had a thread on our like big Slack group about I think someone was hiring somebody in like Pakistan or something,
Oh, geez.
and it was like, you know, how do you do that? Do you use an EOR? Do you use whatever? Like, how should I go about that? And then there's a long thread, and I literally just copied the link to this meeting, and I was like, "Come join us. We're talking about this issue."
Yeah. I think
So,
we're gonna touch like a little bit on international, but not a ton. But yeah, I mean, if people ask questions, definitely for sure.
uh-huh. Yeah,
It's complicated.
I'm sure. Um, yeah, that's better. This is, my hair is like so thin that it's like transparent when the green like hits it.
Brian, it's
Well,
us. No, you look amazing, Brian. Don't worry about it.
Thank you. Yeah, I'm just really, the skin's you got the light in the front, the skin's looking good.
I always say that men age much better than women. So
I think it's dependent on who the man or the woman is and how much alcohol they drink.
when I saw my husband how he looked at 20, I'm like, yeah, I don't think I would date you. We met later in life, so lucky for him.
that's funny.
I need to figure out how to hide this little guy.
Brian, I think you think there's 48 hours to a day. Congrats on your joining the firm, but I don't know where you take the time to do everything.
I'm losing my mind. That's how. And not sleeping that much. But my hope is that once Sam and I kind of get through a lot of this kind of administrative setting up the firm and figuring out how exactly it's going to all work, then we'll start to streamline things. I, it's hard because like I don't want to let clients go because it's a missed opportunity for me. But I'm running out of time, so I really needed to join a firm that was going to be able to support me. And Sam and I do more or less the same thing. We're both fintech lawyers, and it just seemed natural. So he's also great. So I don't know if you ever got a chance to meet him, but he's
No,
a
not yet.
great guy. But yeah, thank you.
It
I
looks
don't
like
know.
he's a solo as well, right? Except that
Yeah.
he has like two of counsels.
Yep. Yep.
Yeah, I
Uh,
joined just for some Czech law firm that has branches in Czech Republic, Poland, and Slovakia asked me to be their US. lawyer. So trying to figure out that part as well now, but it's more work, more corporate work than I thought it will be, and I don't like corporate law. So, and everything is tax related. I'm like, I'm not a tax attorney. Every single time, I'm not a tax attorney. I told you. And they had they had a lawyer who was Czech associate and then came to US and became a US attorney, and he was like a fourth year, and he was just would take on these cases without knowing what he's doing. So, and answering these kind of questions without really knowing the answers. And I'm like, I'm not like that. So they're not used to like hearing like, oh, I need to run this by a tax attorney. So, yeah. So he did immigration, tax, corporate, mergers and acquisitions as a fourth year. Never done it before, but he knew everything.
Wild, wild.
Yeah, I'm like, I'm happy that he stole those clients because they're gonna have some problems and we don't want to be on the hook for them.
Yeah, not my style, that's for sure.
Yeah.
I think people are getting a little bit more risk taking with all these like AI tools. I think anyone thinks they can be an expert pretty quickly, but
Well, he comes from Czech Republic. Czech Republic is like this size, right? So there is literally natural parks that are bigger than our country, and so I think he, kind of underestimates the federal system and 52 states and how everybody has different laws, and yeah, so I think he highly underestimates it. Like immigration law, like I would never do that to anyone.
I wouldn't touch it. Also, it just seems very, not that like everything's high consequence, but like immigration is very high consequence. It's like very personal, really impacts somebody's life, and yeah, and it seems complex, but I don't, not my space. I don't mess around there. All right, let me see if I can highlight or spotlight everybody who's now joining. How many I can do? Sweet. This is working.
Alex came in with his suit. I feel underdressed right now.
No, so I was actually about to ask, do you feel like this is too much? Because I'm a huge proponent of these like really stiff-necked collar polos. So if I take this jacket off, I just look like I'm in a decent polo, which I'm inclined to do right now.
It's a Star World. It's up to you.
I think either way you're good.
You
Yeah,
can
I
never
think
be
so.
overdressed. You can just be underdressed like me.
I was wondering why I'm not getting in the beginning, like jobs at startups, and then I got a feedback from one of the for a startup that hired me, and they like, if you come for a second interview, please don't wear your suit.
Wow.
Just come in
Interesting.
jeans, maybe a nice shirt, but don't do the whole lawyer outfit.
My first board meeting I went to, the when I was new to the startup world, the founder had on like a white undershirt and his hat on backwards, and that was my like, I need to dial down the formality of it.
Yeah, my husband kept telling me like, yeah, no, you're overdoing this, and I'm like, well, you underdoing it. Like he goes to VCs with like jeans with like holes in it, and I'm like, I think you need to dress up a little bit, but it works for him. So yeah, I started dressing down too.
Yana, just so I don't screw it up, how do I pronounce your last name? Is it Borisova?
Yeah, that's perfect.
Okay.
Friends, my power just went out, so I'm joining you from my phone. I'm going to just apologize in advance. I hope that it will come back on. But I was finishing up another discussion, and everything shut down. So one of those exciting.
Where are you? Where are you based, Ryan?
Silver Spring, Maryland. I'm inside the Washington D.C. Beltway area.
Oh, nice. I'm basically from Bethesda, Rockville.
Okay. Yeah, not far. It's a great area.
Very cool. Why is the power out?
We had some freezing rain, and they delayed school for a couple hours, but I can't think of why it would go out, actually. I was just looking over to see my neighbors, all their lights are out too, so it must be, I can't say, actually. I am not sure. But if someone could drive the slides, I think I'm fine, as long as you can see and hear me okay.
Yeah, we can see you and hear you. I think Tess is manning the slides, and then I don't know what you all discussed, but what was the general consensus on like how it would flow? Would we stick to slides or sort of Q&A, or
I
do you
think we're going to ask a general question. Sort of like if you got a new client who is remote first, what are the things you think about? What are the most pressing issues? And then we're going to dive into some of those specific issues. And I made slides on just a few of those so that we could get CLE credit. We can use them as applicable, kind of was what we were thinking.
Sweet.
Hey, can everyone just tell me quickly, I should have done this before, just how to pronounce your first and last name, just so I get that right on the program. Maybe Brian, you are already asking this.
Yeah, and I can do the name intros and then
Perfect.
and just throw it over to you if that works.
Yeah, that sounds awesome.
And then everyone can kind of talk briefly about yourself, because I know we all like talking about ourselves, and then we can get into the presentation.
Trying to find a place that has nice natural light here because also all my lights are out.
Your audio is actually really good for just being on your phone, by the way.
Oh, good. Thanks, Alex. I'm hoping you can hear me. I'm going to let you guys do most of the talking anyway. So
Can you guys hear me well? Because sometimes people say I sound like underwater with these iPods.
No, you sound great.
Okay,
Great.
thank you.
Did you put them in the wash?
No, I didn't. So I went to Apple Store and they think I just needed to update the firmware, so I did, but sometimes people still complain, so.
I put mine through the wash. Ooh,
Okay.
the lights just turned back on. I'm going to try to go join from my computer really quick. Give me just 1 second.
All right.
Sure. Are we public?
Yeah, we are.
Okay.
People are starting to trickle in. We can get started. For those who are joining, we can get started around let's say 2 or 3 past the hours, so we can give people some time to get in and for our host to come back. If anyone wants to put in the chat where you're dialing in from or what you had for breakfast, both are interesting. I'll do mine. Ooh, yerba mate. That's an interesting combo, Maria.
I know. It's actually pretty good. Like, can you see my screen?
Oh no.
Oh, that stuff is very good, actually.
Oh shit, really? Okay. I'm definitely high. Didn't see that coming so early.
Applesauce and coffee. Love it. A lot of sick people. Susan, I feel you. Okay, is Ryan back?
I'm back.
Oh, you're back.
Yep.
Let me pin you so that everyone can see you.
Thank you. I'm on my computer, but I'm instead of my phone. So
Awesome. All right. Well, we're 3 past the hour, so let's kick this off. I'll do a very brief intro and pass it over to Ryan, who is going to be moderating this. So we have 3 panelists who are all from the Hay Council community. Yana Beresova, Alex Castro, and John Yao, all respective experts in this topic. And then Ryan Parker from 650, who is their chief legal officer, is here to moderate. So without any further ado, I'll pass it over to Ryan and let him run the ship.
Awesome. Thank you, Brian. I'm excited to be here. We got together sort of pre-programmed to just chat about some of these issues, and I'm really impressed with our panelists and excited what they have to share. We're going to talk about legal considerations for remote first companies, but let me just get some preliminary matters out of the way first. People are already using the chat. Please use the chat to connect, do whatever you want there. If you have substantive questions, sort of follow-ups on the discussion, stick them in the Q&A just because it's a little easier for us to track. Or actually, maybe there isn't Q&A, so stick them in the chat. We'll find them. We'll also, I put together some slides just to cover some things that we may touch on. We'll send those to you at the end of the program in a follow-up. We may not follow them very closely. I think this is going to be a very organic conversation. But we're just excited to kind of touch on this, and we'll let the conversation go where it does. But I do have some slides just to touch on things that we thought might come up. So here's where I want to start. We're talking about remote first companies. And, in a situation, and I'll just throw this out to our panelists. If you get a call from a new client and they're a remote first company, what are the first things that you're thinking about? And this may be with regard to the company, this may be legal issues, but what are kind of the first things that go through your mind that you're thinking about, the information you need to gather and the considerations that you need to think about when it comes to a new client that is a remote first company? And I'll kick this over to Yana first, and then we can let everyone kind of answer.
Thanks, Ryan. So for the first thing I would actually start considering is which industry is the client in? How big is the company? What kind of services or products does the company provide? Do they have HR? Do they have any international offices and employees? How big is their budget for the revamp or whatever the issue or matter is? Because, for example, retail companies that have a lot of hourly employees or employees that work in shifts will deal with different issues than a software company with a lot of engineers, full-time employees based on salary. And then also, if there are any international aspects, then it will depend. It will also change the matters a little bit differently, basically how to handle if they're contractors or W-2 employees and they are abroad.
Yeah, I mean, I think what I do is a very similar version of what Yana does, but it's a sort of a detailed KYC. Just to give you an example, I talked to 2 clients last week. One was a very small company of 3 or 4 people, and they were hiring their first contractor, and they didn't know the difference between an employee and a contractor. So with that person, I'm really starting from the baseline of like, what simple things do they need to do to get from 0 to 1. Whereas another potential client I talked to was a startup with 3 HR professionals who had handbooks, they had policies, they had the whole system in place. And really what I needed to do there was just support an existing process. So really my first question is, what am I working with here? Because the nature of the client and how sophisticated they are on the HR front is going to really drive the type of advice I provide.
And to hop on that idea of knowing what we're working with, you also want to know what's been the history of the company and what challenges have they faced. A lot of remote first companies are relatively small. They're in the startup space. They're not thousands upon thousands of employees. And so while every lawyer would love to say we have to tackle all of these issues and we need to get it right, the reality is you need to identify your priorities. And sometimes those priorities are what demand letters have you had in the past? What employee complaints have you had? Have you had any regulators knocking on your door? And so when it comes to triaging the problem and seeing what you got to do, let's know where we've been so we can figure out where we're going.
Yeah, I really like all those answers because they're kind of centered on getting to know the client and understand their specific circumstances. And I think that makes a lot of sense with remote first companies, that it's really there's not a lot of one size fits all kind of stuff there. You really need to consider a lot of specifics. So you understand that the company, and then you start to think about the legal issues. What are the most common legal issues that you're seeing come up with remote first companies? And so, we can have this, we can continue our hypothetical. You have this same company. What are the first issues you're asking them about when it comes to legal issues, or you're thinking about? Maybe we can go in reverse order. We'll start with Alex and hit John and then Yana.
I am always incredibly paranoid about wage and hour issues. It's probably because I practice in South Florida, which for either a long time and may very well still be, is the #1 district in the United States federal district where the most Fair Labor Standards Act cases are filed for unpaid overtime and minimum wage. So it's always top of my mind. And so the first thing I want to know too is I want to understand the makeup of the employees that we're talking about. Are we talking mostly about employees that are exempt from the overtime requirements of the Fair Labor Standards Act or similar state laws? And if so, I want to know if they're non-exempt, I want to make sure that we're keeping accurate time records. I also want to double check the company's decision to designate somebody as exempt or not, because it's not a choice necessarily. It's really something that's imposed by law, and something that a lot of folks take for granted is exactly that. And so if you've got people who you pay on a salary basis and you think that is the only reason that you need to categorize them as exempt from overtime, we might be in trouble here, and we might need to do some cleanup on the back end.
Yeah, definitely. I'll say exempt and non-exempt is tricky too. I mean, you have a whole bunch of states that have higher thresholds. You have the job duties part of the test, right? You have the thresholds and the job duties. And then you have this last year, the federal government raising the exempt status in July, and then it being overturned in court and rolled back. I mean, this has been a very, very tricky area. And we had folks that came to us and they said, hey, we gave our folks a raise after the July increase to keep them as exempt, and now it's been rolled back. Can we take that raise back? We were like, well, at your own risk. But I know places did it, and I don't want to point a finger as a Michigan guy, but I know Ohio State University gave a whole bunch of raises and then actually pulled them back after that was taken back. It's a complex issue. John, what are you seeing?
Everything Alex said, because I think running like a non-exempt employee remotely is a completely different ballgame than having someone who's in an office and you're monitoring things like breaks and lunch. But the one that really I keep an eye on, and I feel like this is probably a friendly company side audience, but startups and tech companies are notoriously bad about contractors. They see contractors as a shortcut. It's an employee I don't have to pay benefits to, is the way some people look at it. And that's just going to get you in trouble. I mean, I recently had a call from a panicked founder who was facing a demand for $20,000 because someone had been misclassified, and there's nothing you can do about it. You can't, you can litigate that case, but it's not one you can easily resolve. So it's tough. And one thing I would also caution, especially for people like in California and Illinois, there's a lot of new laws coming out about not just about the classification issue, but even if you're correctly classifying them, how you paper and pay contractors, there's a lot of new laws coming out right with that. So when your contractor is not necessarily a shortcut, sometimes it's the right answer, but it is one you need to do the right way.
Yeah, great answer.
And I would say one of the other things that I'm seeing a lot is also interns. I have a lot of questions. Well, I want to hire an intern. Can I just not pay them? It is possible to not pay interns in certain states, provided that it's linked to their degree, they're still at school, and you work with a school to come up with like a plan that is really, the work is really complementary to the education. But otherwise, if you just want to hire an intern just so you can avoid paying them, that's a really big no-no right now, especially in California. So just be careful when hiring interns and you don't pay them. There are a lot of claims by interns for breaching wage and hour. And the other thing that I've been seeing quite a bit is employing foreign individuals under American offer letters, under American contractor agreement templates, and thinking all is good. And actually, there's a lot of problems with that, because in some countries, even though you give them an independent contractor agreement subject to American law and within the American standards, they can be considered as employees, and then you're subject to some of the employment obligations that employers have in those countries. And it's very hard to fire an employee in many countries. Sometimes if you fire them, you still have to pay them severances, 13 salary. Sometimes in order to fire them, you have to actually go to a court to fire them. For example, in Indonesia, there is no such a thing as unilateral termination of employment. So always watch out for those. And typically, I would recommend always try to hire anybody that is in a foreign country through EOR.
Yeah, Yana, you touched on a question that we actually just got, and I'll just sort of throw this as an add-on question. I'm interested to hear just if the three of you have experience kind of helping companies go through an EOR, which is an employee of record. Those are typically companies that will sort of hire someone for you. They'll be the employer of record in the country, and then folks can work with you. Any experiences, and feel free, any of the three of you, to jump in on this one, because I do think it's an interesting issue. And Yana's put her finger on it, I think, quite well. Having someone in a foreign country, you should not expect that it's the same dynamics as employment in the United States. It often is not at-will employment, and there are a lot of other considerations. So any experience or thoughts about using EORs?
So my experience are pretty good. It really depends on the EOR that you select. So what really I think is important to know for in-house counsels or people that are working with companies is, before there was a structure where the EORs, back then we call them PEOs, would take a percentage of the salary or anything paid to the employee. That's no longer a case. So if you're working with a PO EOR that's telling you, oh, it's going to be 22% or 18%, usually it was 18 to 22% of a salary or anything paid to the employee, that's no longer a case, and then move away from them, because right now it's typically on platform base, where you pay like anywhere between $250 up to $1,000 per employee that is signed up. So you're no longer paying a percentage of the salary, but it's a flat fee per employee. I have good experience with them. Sometimes they're just like a little bit slow because the contract is actually between the employee and the EOR, and you're like a client that can review the employment agreement and chime in, but really it's under the EOR is really the person who is responsible for the employee, responsible to make sure that all the employment obligations are handled correctly, payments are handled correctly. So you're really just the client who is engaging the employee and has certain control. And there are a lot of variations. For example, in Germany, they are cracking down on this EOR PEO system. So you'll see a lot of differentiations when it comes to country, how the contract is structured between you and the EOR, and between the EOR and then the employee. And it's really okay to rely on the EORs. They are very knowledgeable in the space. So for example, when you want to terminate an employee, they will give you a recommendation how to terminate, not to terminate, what are your obligations. So I would, if you do engage EOR, which I highly recommend when you're doing a foreign labor, then you can rely on these companies for even the employment advice.
I mean, I feel like I've been in 50 threads, or I've seen 50 RFIs from attorneys over the last few years of, I use blank employer of record, I don't like them, who do you recommend? And there's a bazillion answers. And I mean, I think the theme I've seen is, some are glorified payment providers, they handle payment, and some are really good at the compliance. But if you're signing up for good compliance, you got to be willing to go through with it, because I see a lot of frustration for companies when they get in these positions Yana's talking about, where they have to pay extra. They don't want to do it. So I think you really got to find one that fits your company and its risk tolerance and its budget. It's not one size fits all, but there are, I think you've all probably been in these threads too. There's a lot of companies in this space, and some are better than others. But I would, echo Yana. I think don't do this in-house.
Yeah, and I'd like to echo one of one of Yana's points on the importance of using an EOR, and it goes back to what Ryan mentioned earlier, how the employment relationship across the world is wildly different. All of your assumptions that you know about, what an employer can and cannot do, and what an employee or what rights an employee does or doesn't have, leave those assumptions at the door when you're talking about employment in different countries. Every once in a while, I'll dabble in like Latin America employment issues, and people would be surprised. They're always surprised when I tell them that in Mexico, for example, employees have a right to profit sharing by default. It's not a contractual thing. It just, you work for a company and the government thinks that is something employees should have. There might very well be some exceptions to that, but that is the general rule. And so if you're trying to navigate an employment relationship with somebody in a different part of the world with very different assumptions, operating under a very, different regulatory framework, you're going to get in trouble if you don't do it without help. And so please knock on an EOR's door, or at least an international employment attorney, so that you have at least some guardrails.
Yeah, I think those are great points. I do think it's interesting as we talk about sort of having employees in foreign countries, how much the law varies, but the law also varies from state to state, right? And I think it is also a challenge having employees in lots of states. And when you have remote first companies, I think they are more likely to have employees in a lot of different states. And maybe we could use paid leave as a jumping off point here. I have a little paid leave slide, but I'm wondering how you're helping companies that have employees in lots of states to navigate things like, for example, all the differences in leave laws and the changes that we see to those laws. I mean, that can be a real burden for companies.
In my experience, that is by and far the hardest administrative task for companies with remote workplaces to keep tabs up. Especially for companies, and it's very common that these companies have maybe one employee in a state, two employees in a state, and you're not even sure if you fall under the statutory definition of an employer within that state, and you're kind of wondering, well, do I even need to offer paid sick leave or paid leave under this framework? And most of the time, there really isn't an answer to that question. It's a question that's unresolved by statute or by the courts, and so if you don't want to provide the leave as provided by statute, you run the risk of getting in trouble for that later. And administratively, it's tempting for an employer to want to take that approach, because you've got one state where an employee accrues sick leave 1 hour for every 30 hours worked, another one where you accrue 0.0837 hours for every 10 minutes worked, and you kind of don't even know how to keep tabs of it all. And so it's one of those tricky problems, and one that is increasingly getting bigger as legislatures continue to pass those laws.
I mean, I've seen what startups, I think, or tech companies often do is they paper over this by doing unlimited vacation, meaning we're paying everybody all the time. And I guess theoretically, if you are paying everyone all the time, if someone, goes on, has jury duty or their parents get sick, you're probably going to be covered, even if you're not doing things exactly the right way, because the person's going to be happy. But as you get bigger, you're going to run up against a point where you can't do that anymore, and the founder's going to get mad and say, people, that's not going to work out anymore. And that's when you really, I mean, good to go back to what we said. I think you really do have to rely on tech a little bit. You don't want to have to hire a employment law. You can't have 50 employment lawyers throughout the country. There's good handbook providers that put together state-specific handbooks that have the rules. And my rule of thumb is, if someone's taking time off work other than vacation, there might be some leave implication. And if you have a good handbook, you can check it out and do the best you can from there.
But there are, like John said, there are a lot of tech providers, platforms where you just plug in the state and it will tell you exactly what are the obligations. So it's like an HR platform that will help you with that. Or even 650 has a good platform. And I'm sure Ryan can talk about it more. They're amazing. They have a lot of resources when it comes to different states, not only just leave laws, but all the different nuances, for example, non-compete. But I'm sure, Ryan, can you talk about a little bit about it more?
Yeah, thanks, Yana. When we think about this, it's something that's very hard for an individual or a small company to do, but technology allows you to sort of scale it. And so we have a team of attorneys, and we dig in and we have a handbook generator, for example, where you just put in your states and it'll give you all the required policies and help you to kind of put that together. And then every month we send out updates for those states, for all the states. And so not only can you create a handbook or an addenda, you can stay up to date on it. And so that for us, that is used by both companies and by practitioners, both HR consultants and attorneys, as a back office tool, but also directly by companies. You know, one of the things I wanted to touch on that I think is interesting, I'll just jump on my soapbox here for a minute when it comes to unlimited leave. I really don't like the term unlimited leave. And every time we have a customer that's like, oh, we have an unlimited leave policy, I think, actually, you don't. No one has an unlimited leave policy. You're not going to pay people to be on leave all the time. So please use flexible leave. But as John said, you know, it may work when you're small, and I think it's often a good option, but you have to remember and understand what you're getting into, because some states, for example, require you to pay out vacation at the end of employment, right? And if you just say, oh, I clump everything into PTO in California, you're probably going to have to pay out, you know, your flexible leave policy. You're going to have to figure some of these things out. And so it's not as easy as just saying, oh, we just provide flexible leave and then putting up your hands. A lot of times there are other rules that go along with that. And I think that that's something to keep in mind when you're thinking about a flexible leave policy. I do like flexible leave. We have flexible leave at 650. I think it's a great, employees enjoy it. It does lower the administrative burden, but it does not eliminate that burden. And you still have to kind of make sure that you're complying with a lot of these different kinds of laws.
So just to piggyback on that, for example, for San Francisco or the Bay Area, you have to provide 3 sick days. Actually, it's just going up. So you need to document that you have provided those sick days to the employees. So what you do need to do is actually keep track of it. So if an employee takes a sick day, you have to record it. And so companies that have flexible time off or PTO, they typically forget about this. And actually what should happen is that you pay the employee upfront all the 3 sick days or 4 days, what it's going to be now, instead of just like keeping it open and saying everything is flexible. And not only that, you also have to document that you made that available to the employee and they can actually take it or took it or they got it paid out. So like Ryan said, just because you have flexible paid policy doesn't mean like, okay, that's it. You do have to create all these other ways to track whether the employee took the vacation or these sick leaves that some counties are requiring or states requiring. It depends county to county, of course.
Yeah, I'll just say one more thing. The other thing that I think is hard about sick leave is that it changes really rapidly. I made this slide just because we have 4 states that are adopting new sick leave laws here in 2025. And they're not the states you would think, right? You might think, oh, sick leave, that's for, you know, the states on the coast. Like a lot of states are adopting sick leave, some through voter initiatives, which I think is interesting. But these change, and these are things that employees really care about and regulators really care about. And so if you're only updating your handbook like in December, you may, you know, Michigan's changing on the 21st of this month. You may miss Michigan for several months, or Missouri or Alaska or Nebraska, and kind of put yourself in a tough spot. I think that's one of the things that's really hard about leave. It's an easy transition, though, to the next thing I wanted to ask about. You know, we're talking about policies. How do you help your customers or your clients when it comes to policies, employee handbooks, keeping them up to date? What are some of the best practices you're seeing for remote companies? Because I think remote companies, because they're more likely to have employees in multiple states, their burden's a little heavier than someone that just has employees in one state. What are you seeing? How are you helping companies, or what are you seeing as strategies that are working for them to keep handbooks up to date?
I'll start that one. So I've got 2 clients who have that issue regularly, where they've got employees all over the place, and they want to keep their policies up to date. And for better or for worse for them, I've convinced them that you should generalize and make uniform the most the most generous leave rights throughout the country, right? So what you can do, one option that you can do is you can have, a base handbook that applies to the whole country, and then have individual state addenda for that. But that becomes kind of difficult to track and manage sometimes. And so I tell them, for the sake of administrative ease, take the state that's got the best sick leave, or whatever leave you might be talking about, and make that your default policy, and track that state as your default policy. The good thing about a lot of remote first companies is that a lot of them are in the tech space, who are already pretty decently inclined to want to be good to their employees in these regards anyway. And so it actually makes it quite easy for them, so that even if a new state passes a law that kind of fell under the radar for them, they may very well have already been in compliance with it anyway. And one quick plug on that point: if you're like me and you look at all these laws for a living, you'll find that so many of them copy and paste each other. And so if you read a new law from one state, you've probably read a very similar statute from the state that just passed it a year prior.
I'll go back a step too. I think there's a lot of fractional GC types and maybe some in-house on here. And I know going to a founder and pushing an employee handbook is like, that utilizes your internal capital. But I think it is one of those things you do need to put on the list, because if you ever, so it's worth doing as a baseline consideration, because if you ever have some type of discrimination issue or demand letter, like, you wouldn't at least say, like, we had an anti-discrimination policy. We had these policies in place. So like, it's, as a base consideration, you should definitely have a handbook. And I also like Alex's approach. I don't think you want to make something that is a playbook for every scenario in the world. You just want something very generic, that's generally applicable, that's not going to change every 5 minutes, but you got to do it. And again, going back, like, utilize tech for this to the extent you can, and have a lawyer look at it as a second set of eyes, is my advice.
Yeah, like John, I also use tech because it's the fastest, it's the most efficient. So if you're working with startups, it's just, even from fee perspective, it's the best for your client.
I want to jump on something that Alex said, just because at 650 we do help companies make handbooks, and so we think a lot about different types of handbooks, and there are different structures that I think work well for different companies. What Alex described, sometimes we call that the universal policy. You create as many policies as you can in your core handbook that apply to everyone, and then you need still to have state addenda for things like your EEO policy that maybe has to include the state office, EEO office, and things like that. And you'll maybe need some state specific disclaimers and the like, but it is nice to be able to get as much as possible in a core handbook. We've seen companies that make different handbooks for people in all their states. It's not my favorite way forward. It's easy to do. We have an engine, so you just put stuff in, but it's hard to update, and it feels like it's not very transparent. We have some companies that just put all their policies, they're state specific, and they just put them all in their handbook. And so there are lots of different ways to do it. But I think, as John said, the key for me is that you want your handbook to be a resource for your employees, and to be something that heads off issues before they fester. That is, if someone gets a jury notice, it's nice for them to be able to go into the handbook and see how to take leave, rather than have to call someone and talk that through. And so there's so many ways that you can make your handbook a resource, and hopefully sort of smooth out a lot of situations before they present themselves. I want to go back to a question. I think John was the one that raised this initially, but we talked about exempt and non-exempt employees. This is an issue I think that a lot of employers have. I think it's a little bit scary, because I think you have a lot of employees who are misclassified when it comes to being exempt, non-exempt. And maybe we could just jump in here and talk a little bit about what you do when you have, a remote first company where you've got people all over, and you realize that they really haven't looked at this exempt, non-exempt distinction. If they're a tech company, maybe they just assumed everyone's exempt. How do you address that? Like, what are the practical steps, and how do you kind of help a company walk through what could be kind of a painful process of realizing that actually not all their employees are exempt?
So the nice thing about going through that process is that it's very grounded in reality. The question of whether or not somebody is properly classified is really the the core of it is, what does this person do on a daily basis? And so that's a discussion that can be relatively easy to have if you know what your employees are actually doing on a day-to-day basis and your job descriptions are up to date. But it's not a particularly nuanced discussion, right? So your entire assessment is, well, most of the assessment is on what does this person do, and does this qualify under a certain exemption, white collar or otherwise, under the law. Where I have found that analysis becomes very difficult is in a lot of remote companies are fast moving companies. They are companies where somebody's job one day is not their same job in 6 months, because either they've gotten a promotion or because the business of the company is moving so quickly that people are just kind of wearing whatever hat needs to be worn that day. And that's where I've seen, I actually saw maybe about a year ago, a pretty decent penalty from the Department of Labor for an employee who was kind of in that position where her job had just changed rapidly over the course of a year and a half, and she lost her white collar, or she gained a white collar exemption status maybe 6 months in, and we had to kind of unwind all of that in terms of what was this person owed, when were they owed it, when were they properly classified, all that sort of stuff. So I start with the basics. What on earth does this person do?
Yeah. I'll jump to the end and give an anecdote of one of the things I underestimated with this process. Is I agree with Alex that it's cut and dry and you get to an answer, but one of the hardest some of the hardest conversations I've ever had with employees is to tell them you were exempt, you're now non-exempt. And I underestimated this, but there's a perception among a lot of people that exempt means you're an executive, you're a decision maker, you're relevant within the company. And then telling someone you're now non-exempt, I think a lot of people equate that with, like, this was my part-time job in high school. I'm not, I have to track my time. I have to tell you when I'm having lunch. I don't really like this. So even getting to the right answer, how you do that is a very complicated thing that involves like employee self-perception. So, stick the landing with this, even if you have the right answer. So that's just, having had some tough conversations that I underestimated, I offer that to everyone.
And also you have to work with your client. So even though your client came to you and said, well, I need to figure out if my employees are exempt and non-exempt, don't think that they are ready to hear the answer, because if you tell them, well, they are actually non-exempt, then they might not want to hear that. I had a client who literally came to me to do this exercise, and when I told her, well, except one employee, they are all non-exempt, they were fighting with me to make them exempt. And so at the end, all you can do is tell them the analysis, give them the reasoning, and make it their decision to decide if they want to go, which route they want to go, and tell them definitely what are the risks if they decide to go the opposite route than what you're recommending, and how much it will cost them.
The point is really well taken. I'm a huge believer that behind every employment law issue is a human and a people issue. And so the question of whether or not somebody's exempt or not is not just the math calculation, but it's also a deeply personal one, because a lot of people their identities are incredibly intertwined with what they do for a living. And whether or not somebody's salaried or exempt or not is, quite frankly, a status symbol for a lot of people. When you stop getting paid hourly and you start getting paid on a salary basis, you feel like you've made it, kind of idea. And if you have to ever walk that back for somebody, that does, some real emotional damage for a lot of people that can have implications that are not just, on the balance sheet.
Yeah, such an interesting point, because the irony there is that non-exempt status is really intended to protect employees, right? Like, the idea is that you don't want employees to be paid a low salary and then not be paid for overtime, for example, or not be subject to being able to take breaks or things like that. And so it's interesting because, as Yana said, employers want all their employees to be exempt, and employees maybe see it as a status symbol. But I think for a lot of employees, being categorized as non-exempt would make them more money, because every hour they work over 40 hours, they're going to have to be paid time and a half in most places, right? Like, it's a protection for those employees, and potentially a salary increase but it also, I guess, maybe comes with a stigma. It's a really interesting dynamic there. Well, let's jump in. I want to talk about one other thing before I definitely want to spend some time on employee contractor, but let's talk about overtime rules just because we touched on that. You know, this is an area where I have heard some very scary stories from folks who have not realized that we have sort of a federal overtime rules under FLISA, but that states also have overtime rules. And John, I think you're in California. You may be aware of this, but California has some very generous overtime rules. And I know I talked to an employer who got a pay suit brought against them because they were paying based on overtime being more than 40 hours a week, where in California, there are actually 3 different ways you can have overtime. And one of them is working more than 8 hours a day. How do you help? And I know Alex mentioned this too as one of his first issues, but how do we help our clients to think about overtime and to make sure that they're being careful when it comes to pay related rules?
I think it's really hard. I mean, the clients we all have are people who are companies that expect perpetual availability and instant responses at 2 o'clock on Saturdays. It's not it's not 9 to 5 office jobs where this is a lot more manageable. So I think it's really just educating people of what overtime means, and that you can require people to work whenever you need them to. You just have to pay them. There's just a cost to that. If you want to write someone on Saturday morning and make them spend an hour and a half doing something, and then ping them again Sunday, and they've worked 15 days in a row, you're going to start paying double time in California. Those things are going to happen. So it's just educating people that it's not, the point is it's not okay. It just has a cost to it, and you got to pay the price.
If you don't, the consequences are pretty serious. Yeah. Sorry, Anna.
And then also we should maybe, since we were talking about the international aspect, we should also consider when you're doing it in the European Union or LATAM. So, I mean, in APAC. So when you're working in APAC, if you have a salaried employee, they are okay working your American hours, as they call it. So working late at night, working a little bit more than 40 hours a week. But if you come to Europe, the moment you ask somebody to work 40.5 hours, they either going to tell you no, or they will ask for additional money. Having them work on a weekend, you're going to come to a lot of resistance. And actually, as an employer, you have no right to force them to work. So if they say no, it's not like you can go back to them and start convincing them they should, or try to retaliate against them, even though it's illegal here as well. But there, they take it very seriously, and the employees get really upset if you ask them to work over the weekends or after business hours without any sort of remuneration.
Yeah, I think it's a great point. I just think this is a really interesting area in that a lot of companies, this is tied directly to exempt, non-exempt, right? They think, oh, I'm going to have all my employees be exempt so I don't have to worry about overtime. But as soon as you have a non-exempt employee, and I think a lot of companies maybe have employees who qualify as non-exempt and they don't realize it, you also have the overtime rules that can vary from state to state. And I think that can be a real challenge. And I think companies need to be vigilant about what those overtime rules are and make sure they're following them. I want to save a little bit of time, and why don't we transition now to contractor and employee sort of rules. This is, I think, has been a big issue, will continue to be a big issue. The slide I put together actually just talks about sort of the different tests under the Trump administration. The first time under the Biden administration, I think we'll probably go back to this Trump administration test with only 2 factors. But at the end of the day, I think the issue here is that you have a lot of companies that, and we've touched on this already, that want to hire contractors instead of employees. And that actually was something that was somewhat unchecked for a period of time. And that period of time, it feels like is over in a lot of states. What do you do, when you start working with a client and you realize that they have contractors that really are employees? How do you handle those? Those have got to be tough conversations. How can you help your clients to deal with that? And how do you maybe even flag that issue in the first instance?
I've told a lot of founders this contractor is probably an employee and they don't want to, sometimes they just don't want to hear it. So I think the first thing I really try to do is, I think even if you're going to have contractors who are on the line, do not pay them in a very simple way in terms of have an hours cap so that you know what your exposure and your liability is. What I really try to advise people not to do are these really complicated contractor agreements where you get, a percentage of equity based, you get equity based on the number of sales you have. And it's just this very complicated formula. I think that's where you're really going to you're compounding your risk. So I think the first thing where I can get some traction is, if you're going to do this, at least have simple contracts. And then let's talk about how to make sure we have people classified properly.
I like to start with some good old fashioned fear mongering, and wage and hour stuff. And this falls under wage and hour issues in also many ways. Is my favorite place to fear monger, because people are just not educated on what the costs associated with getting it wrong are. I always like to tell people, whether somebody's a contractor or an employee is not a choice. You don't get to decide that. The DOL knows what the right answer is. The IRS knows what the right answer is. It's your job to figure it out, just the same way as you have to when it comes to filing your personal tax returns. Plaintiffs' lawyers typically often know who's right, and the costs associated with those lawsuits are insane. And so I don't really have it on me. It's on a drive somewhere where I actually have awards from the DOL and the DO and the IRS and jury verdicts of the amount of money that people have had to pay out on these misclassification cases. And just as an example that came off to mind, my first 2 years of practice, I had a waitress at a restaurant who was owed $2,000 of unpaid overtime, and the employer ended up having to pay about $30,000 total because of costs, attorney's fees, all of that sort of stuff. And so the fear and the shock in their face often helps get the message across, at least in my experience.
Yet, I think this is an interesting one. I will just say, for those that are interested in how this test is likely to change under the administrations, both administrations claim that they use the economic realities test, and they just sort of shuffle the factors around a little bit. And at the end of the day, I think people that watch this closely aren't sure that there's actually any practical difference between these two tests, even though the Trump administration test was supposed to allow more people to be classified as contractors, and the Biden test was supposed to lead to more people being classified as employees. I still think that these factors are generally the same. And if you're controlling the work and you're controlling the opportunity for profit and loss in particular, then they're very likely an employee, right? I mean, that's just kind of the nature of it. And I think especially in tech, but across industries, you have so many people who are working as contractors who really are employees, and that is just an area of extreme risk for a lot of smaller companies.
And I mean, to Alex's point, there is an element too of doing the right thing, because the reason people don't pay people as employees often is to avoid insurance and benefits. And I think you've got to keep in mind how you're treating people. But on the other side of this, one way I do tell companies you can mitigate this is within your contractor agreements. And I think a lot of the form ones out there don't have this, is you should have an arbitration clause, because if you're arbitrating these things, they are much, much less appealing to a plaintiff's attorney, because a plaintiff's attorney would much rather go to San Francisco Superior Court than some jams tribunal. So it's unfortunate, but that's the way. That's one way to mitigate this risk for companies.
Yeah, that's great practical advice, John. Okay, let's just do quickly, because we're about 3/4 of the way through. Why don't we do the CLE code? For those that are interested in getting CLE, please write this code down. We can't send it out after the program because of CLE requirements. I'll read it out so it's for those that are maybe following around along with closed captioning. It's 988 EMW. Again, that's 988 EMW. And we'll send a follow-up email so that you can know what you need to do, you'll need to email and we'll send you a form and you put this on it. So, but for those that would like CLE, there's your code. Okay, we have about 10 minutes left in the program. We've touched on, I think, a lot of sort of the legal issues that that we flagged initially as sort of things that come up often when it comes to contractors or when it comes to remote first companies. I want to just sort of pull out the crystal ball a little bit and kick it over to you to sort of share some thoughts you think about what may be coming down the pike for remote first companies. It's interesting. I think the pandemic sort of accelerated remote first. And for a while we were in a time of flux, but I think it's clear that remote first companies are here to stay, that this is a construct that works for a lot of companies. And I'm curious to see or to hear kind of what you think about sort of the future of remote work, if you're seeing trends or if there are things that you're worried about or things that you think that could be positive developments for remote first companies.
I'll go ahead and start that one. I think one of the trickiest parts about remote work and employment laws is that most of the employment laws on the book operate under the assumption that employees all exist under a roof and they're, you know, within the same place. And the law just hasn't really contemplated the possibility that you can have a workforce that's just all over the place. But last year, when the Federal Pregnant Workers Fairness Act passed, and this might have been an implementing regulations, I don't remember exactly where I saw it. There was an explicit recognition that teleworking can be like a presumptive, reasonable accommodation for pregnant employees who need an accommodation. And what that kind of signaled to me was legislators are now thinking about remote work when crafting employment laws. And I am hopeful that as the years go by, the obligations that an employer has with respect to remote workers will be a lot more clear. I think that's what I'm seeing, and I continue to hope that's what I'm seeing, because to me, one of the most confusing parts about remote work and employment laws is, does this apply to me, and how does this apply to me, and how do I make it work in a non-traditional work environment?
Alex, I really hope you're right, that maybe the legislatures of all these states have realized, have caught up, and that we'll see clarification here and a contemplation of remote work that will make the law more clear, because that uncertainty is tricky.
I mean, I don't know if I have a crystal ball, but I am very curious how the national political dynamic is going to impact this, because I think within that there's a lot of hostility to remote companies. And I think, you know, I think remote work is here to stay, but I think there will probably be a lot fewer remote companies as time goes on. I think there's certain roles that will be in, you know, a good engineer is probably, like, people will make an accommodation for that. But I think this, as companies that are inherently remote, I see that probably going down given a lot of the issues we've talked about today.
And you have a lot of big companies that are kind of trendsetters that are moving towards a return to office model, which I think is interesting. I'll just say one more thing before we kick it over to Yana. I do think that the change in administrations and this new administration sort of approach to employment law, which I think is going to be complete hands off, is likely to sort of pass the baton in some respects to states who are going to fill that gap. And I do think that you could see an increase in state regulation of remote workers and a lot of different employment laws, because in the past, you know, under the Biden administration, we had a very active FTC, NLRB, EEOC, and I think that those agencies, to the extent they still are functioning under this new administration, are going to be much quieter. So I do think you can probably count on an uptick in state legislation and the variance between states. Yana, what do you think is coming down the pike?
I think there is going to be a lot of also crackdown on the international hiring and how it's all going to be taxed, just because this administration seems like wants to keep jobs within the U.S. So I'm awaiting that a lot of things going to happen in that area, and then also immigration.
Yeah, I think those are both big. I know that I have heard a lot of questions about, what do I do if ICE shows up at my workplace? What do how do I prepare for, for example, an I-9 audit at my workplace? So immigration is certainly on people's minds. And that contractor issue, I think is an interesting one. I guess we just have another, I've got a whole bunch of topics I wish we could hit, but I also just am curious, as the three of you, serve in part as fractional counsel for all these different companies. I'm also interested in what you think of sort of the future of fractional counsel is. I know this isn't a new thing necessarily, but this idea of kind of helping these companies that don't have their own counsel and almost being their in-house counsel. Interested to hear just what your thoughts are about where that may be going in the coming years.
So I would think that there is going to be a higher and higher demand. When I started my firm, it was just during COVID, and the demand has grown. And the COVID allowed, especially any company, to hire an attorney anywhere. So for example, before COVID, I felt like if there was somebody hire a remote attorney or outside counsel, they wanted to be in the state where the company had the headquarters. But during COVID and after COVID, like, we get a lot of demand from East Coast companies or European companies to hire attorneys in America or even on the West Coast. And also just being in-house or outside, I call it outside in-house counsel for bigger startups, they are finding that the bills that they receive from the mid-size or larger law firms are just enormous, and they definitely don't. Some of these work is not worth $1,500 or $1,000 per hour, and so they are looking for more and more for solo practitioners or practitioners with like just two partners and maybe an associate to really help with just the employment laws, the employment compliance, the privacy compliance, and the transactional deals, definitely.
I actually agree with Jana's point that there's going to be an uptick, and I'll take it a step further, and I'll say that attorneys as a whole have not done a great job at like meeting the market where it's at in terms of what do clients want in terms of pricing and billing and expectations and all those sorts of things. But attorneys who have been quick to brand themselves or rebrand themselves as fractional counsel, they get it, and they are the people who are in the best position to market themselves to these companies and demonstrate to these companies the value of having fractional counsel on hand. And so even on just that front alone, on kind of finding product market fit, I guess we'll call it in a roundabout sense, it'll increase as those types of attorneys break down the barriers that a lot of like remote first companies might have against the idea of a stuffy law firm and lawyer.
I mean, this is a Hey Counsel panel, so a little biased, but for all of you, I hope it is very successful. But I will say, I tried the fractional work when I started my practice. I found it incredibly hard to do, just because you go from one demanding founder to four who think you're perpetually available. So I've actually moved away from that because I found it very challenging to do. I'd rather solve people's problems rather than be their day-to-day counsel. But for those who do it, I respect you and very impressed.
Well, we're at the top of the hour. I've really enjoyed this conversation, and one of the things I've enjoyed the most about it is the different perspectives. So I appreciate you jumping in and sharing different views and things, and that's the nice thing about a panel is we have different practices and perspectives. So thank you for jumping in and talking about remote first companies. I hope this has been a helpful webinar for you. I know that at 650 we're grateful to Hey Counsel for co-hosting this with us. I really enjoyed the conversation. And Brian, can I kick it over to you to just give us any final thoughts or announcements here?
Yeah, I mean, I can't thank you all enough. Jana, Alex, and John, I'm extremely impressed by your knowledge in this space, and so thanks for lending your time to us. Massive thanks to you, Ryan. I think you have a career in moderating in addition to being chief legal officer. So really well done. And I think for all the Hey Counsel members on the call, know that 650 is a resource for us. If you go to the perks page, please check them out. If you have any questions, reach out to me. But anyone on the call, I think 650 comes really well recommended by a lot of members in our community. So definitely worth checking out. And I think that's all I got. This was awesome. So hopefully we get to do this with 650 again sometime soon. And please join us for our next webinar.
Beautiful.
Bye.